Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. It's Christmas Eve, and we're continuing on FBI violation of Fourth Amendment civil liberties under the guise of administrative law, the case of Snitko versus U.S. out of the Ninth Circuit. It's actually something I enjoy reading from the Ninth Circuit. There's a lot of interesting detail that we're going to get to today. We stopped at 1255 last time. We're continuing at the bottom of 1255. The preparation and execution of the warrant. I'm not going to summarize what we did in the first episode. You can go look at that, and that's why it's there. So I would say just watch that or listen to that. The agencies prepared two relevant documents prior to applying for the warrant in preparation for the search at USPV. One is the Operation Order Search Plan document. That document states that agents will seize and inventory the facilities of the business, including the nest of safe deposit boxes, according to the federal seizure warrant, which had not yet issued. The portion of the plan titled Execution explains that, quote, teams 1 through 4, unquote, would search the residences of the owners of USPV. Team 5 will execute a search warrant at USPV and will seize evidence itemized in the warrant regarding underlying crimes, money laundering, fraud, drug trafficking, etc. Team 6 will process and inventory the facilities of USPV, including the nest of boxes. The document then refers the reader to the second relevant document, supplemental instructions on box inventory. Pay attention. This is where the administrative law tries to sneak in. If you heard the term seize, right? That's a constitutional issue right there. Why? It's in the text of the Constitution, the Fourth Amendment. What they're trying to do is get around the Fourth Amendment by administrative law and hoping that nobody's paying attention to this. The supplemental instruction, I'm on page 1256 now. The supplemental instructions begin by explaining that pursuant to the warrant, not yet issued by Magistrate Judge Kim, agents are authorized to seize, there's the constitutional word right there, the facilities of USPV and conduct an inventory of the contents therein. Inventory is not in the Fourth Amendment. So what do they really want? They want to seize everything, but they can't. Not legally. Not under our constitutional law, they can't. Not according to the warrant, they can't. Why? Because there's innocent people involved. Their property is involved. You have to have due regard for that. Okay, how about an inventory? Ah, see, that's got some fingernails you can get under there with the administrative law. So they're calling it supplemental instructions on box inventory. It's clever. I have to tell you that. It's clever. All right. agents were to search, that's a Fourth Amendment term, and inventory. Why do they have both? Why do they have both of those words? Well, it's because they can't search everything. They want to search everything. They can only search a portion of it. They want to search 100% of it. So constitutionally, they can only search a portion of it. They need something else to get them the rest of it, the 100%. That's going to be the inventory. So they can search constitutionally a certain portion of it. Whatever is that portion, 100% minus that portion is what's left over. They're going to use the administrative law, the supplemental instructions on box inventory to get us what is in effect a search and seizure of that stuff. Are you guys following this? All right, here we go. Agents were to search and inventory all boxes according to FBI policies and procedures, unquote. All inventoried contents are to be processed as described in the memo. The first part of the memo, titled General Procedure, provides instructions on how agents should conduct their inventory and log the contents of boxes. According to the memo, 2 teams of 3 agents were to methodically open and inventory each box. That sounds like a search to me. Is it a search or is it an inventory? Yeah, it seems like if you just had the box sealed, and I don't know how these boxes are sealed or locked, but it seems to me that what you're really concerned about is that there's no danger posed by the box in the facility, like, for example, that it has explosives, right? Or some kind of biological threat or something like that. Um, all right, let's move in here. Let's move into some of these details. Um, and I'm interested in what you think about this. Is this shady or is this legitimate? Let me know what you think. Am I missing something? Am I missing something? Because I'm reading this and I think the judge that's writing this and me are thinking the same thing. I think that we're being suspicious of the FBI, and rightly so, because there's some very interesting shenanigans. Now, I mean, if you're pro law enforcement 100% of the time, they can never do anything wrong, back the blue and all that, then, you're not going to have a problem with any of this. But law enforcement is not supposed to target innocent people, and they're not supposed to violate constitutional rights of innocent people. I appreciate the cleverness of what they're doing here, and it might be effective in actually capturing criminals, and I mean immoral criminals, but we're not supposed to sacrifice innocent people to get that. And that's my concern. The first part of the memo, titled General Procedure, provides instructions on how agents should conduct their inventory and log the contents of boxes. According to the memo, 2 teams of 3 agents were to methodically open and inventory each box. This involved removing the box, labeling it, and taking care to preserve possible fingerprint evidence. Teams would then identify the contents of each box, creating an inventory list and filling out various forms. The memo states that each inventory would likely include the following: the USPV box door with its lock, a form with emergency contact information, the physical deposit box, and the box's contents. Although the memo instructs agents to identify the box's contents, it does not provide further instructions on how to do so. Ah, how do you identify? And that's the word that Judge put in quotations. Identify the box contents without doing a search. You have to do a search. The problem is that you're not allowed to do the search constitutionally. Or are you? Does the administrative law take precedent over constitutional law? Separately, teams were to note if the box includes a USPV notification form identifying a contact person for the box. The memo provides that agents could not search the box, the content of boxes for evidence, but could examine the content to identify the box owner. Does this sound like doublespeak to you? Inventories of each box would be video recorded, and a copy of any paperwork would go to asset forfeiture team. All right. The next part of the memo provides more specific instructions on how to secure and handle evidence. For example, any amount of cash over $5,000 was to be placed in an evidence bag. Very interesting word for that. Evidence. Oh, it's evidence. And given a forfeiture identification number. Any cash would then be taken to a canine unit, which was on the scene. That sounds like a search. That sounds like a seizure, and it sounds like a search to me. Doesn't sound like an inventory. Are you catching this? You put it in an evidence bag, that's a search and a seizure. And forfeiture number, that's a seizure. That's not an inventory. Are you following this? See, the FBI screwed up there. They say they're doing an inventory, which is an administrative function, not a constitutional search and seizure. But then the way they're processing it is as if it was a search and seizure, which is what the evidence, that's the evidence that the judge is taking of what their intention was the entire time. Agents were to take notes on the condition of cash, including how the cash is bundled, rubber bands, bank bands, if it has a strong odor, marijuana, soil, gasoline, coffee, chemical, if there appears to be a drug residue present, if a gun is also present, or anything else of note. To facilitate that sounds like a search, a criminal search to me. Doesn't it sound like a criminal search to you? To facilitate the inventory, the FBI also created a form specifically for use at USPV. The form includes a space for cash observations and, like the supplemental instructions, tells agents to record how the cash is bundled. This is a very strange inventory. If it has a strong odor, does that sound like a normal inventory to you? It sounds like a criminal search to me. And if drug residue or a gun is found with the cash. Why would you be concerned about a gun? It also includes space to record the results of a drug dog sniff. That's definitely a search. Any use of a drug dog is a search. It's a criminal search. And it prompts agents to record as a part of the inventory serial numbers on firearms or watches. Well, of course, that would be part of an inventory. Now, notice the word inventory again. Execution, 1257. The government executed the search and seizure warrants on site at USPV from March 22nd to 26th, 2021. During that time, the FBI inventoried the contents of over 700 safe deposit boxes. I bet they thought it was Christmas time. In performing the inventory, inventory is in quotations, agents found letters taped to the inside sleeve of the deposit box, identifying the owner of the box and providing the owner's contact information. The district court found, however, that occasionally, even after finding these letters, agents would break open the interior of the box and inventory the box's contents occasionally. Occasionally is in quotation marks. That's what the district court said. Oh, so, okay. This is the appeals court, the three-judge panel. Everybody gets an appeal at the district court. This is overturning, reversing the district court's decision in favor of the FBI. Per the supplemental instructions, agents used the inventory form to document the condition of the cash. Well, that sounds like a criminal search. Ran all cash over $5,000 by drug stiffing dogs. That's definitely a criminal search. Tagged items with forfeiture numbers. That's a seizure. That's evidence that they intend to seize it. And photographed objects found in the boxes. That's something you would do in a criminal case, in a criminal procedure. All cash was taken to Loomis, which generated receipts. Oh man. And the money was wired to the U.S. Marshals Service. Wow. So they took the money, they seized the money, they deposited it. Oh, wow. Okay. All non-cash valuables were transported to evidence control for storage. That sounds like a criminal. That doesn't sound like an administrative inventory. That sounds like treated as seized, criminally seized contents. All general evidence was inventoried, processed, and labeled and taken to FBI ECC, and that part's it redacted out for storage. Okay, so what you have here is you have innocent people's stuff mixed in with criminal stuff. They're only allowed to, they're not allowed to criminally search everybody. They can't do that. They don't have probable cause for all of these boxes. Okay, results of the search. Despite the affidavit's assertion that it would be irrational for non-criminal customers to choose USPV, that sounds really strange to me. It would be irrational for non-criminal customers. Why would it be irrational? It turned out that a number of non-criminals were customers at the facility. How in the world do you come to a conclusion that it would be irrational? These include the following plaintiffs: Paul and Jennifer Snitko, who used their USPV box to store legal documents, watches with sentimental value, hard drive backups, coins, gold jewelry. They used USPV because their bank had a waiting list for safe deposit. They live in a wildfire prone area and they require a place to store their wedding bands when engaged in sporting activities. Tyler Gauthier, who stored silver and other personal property in his box and used USPV due to its convenient location. Joseph Ruiz, who stored 57,000 in cash in his box and used USPV because he was concerned that the COVID pandemic would make it impossible for him to withdraw funds from a bank account. Michael Stork and Jenny Verdon Pearsons, who stored approximately 2,000 in cash as well as approximately 20,000 worth of silver, along with personal documents in their box. They used USPV because they needed a safe place to keep the silver. Getting a drink of water. That doesn't sound irrational to me. Travis May. Besides, is it a crime to be irrational? Is that crime? I mean, it's not irrational, but even if it was, Travis May, who stored 63,000 in cash, 100,000 in gold, and various documents in sealed envelopes in his box, and used USPV as an alternative location to access valuables in case of emergencies. After the raid on USPV, plaintiffs filed claims with the FBI seeking the return of their seized property. It was seized. The government did not return the property in response to these claims. See, that's interesting. That is very interesting. Why would they not return the property? That tells you something, guys. I hope you're paying attention to this. Instead, it indicated that it was seeking to forfeit the property, that is, to seize it. That was its intention the entire time. They weren't authorized to seize it, though. So on May 20th, 2021, so that's about a month and a half later, or 2 months later, the government initiated administrative forfeiture proceedings against any box contents that met a minimum monetary threshold of $5,000 by issuing a notice of seizure of property and initiation of administrative forfeiture proceedings to USPV. Why would you have a box like this if you weren't going to store something more than $5,000 in it? That's the whole point of having a box like this. See, it's like you're trying to criminalize through the back door innocent conduct. And that's the same thing that it has in common with gun control. Gun control criminalizes innocent conduct. Think of the assault weapon ban, the so-called assault weapon ban in California. It's innocent conduct to have one of those silly bullet button rifles, and then all of a sudden you're criminalized for having one, unless you go through some administrative process. But how can an administrative process make the innocent, make the guilty innocent? Uh, and how can merely passing a law make the innocent guilty? And it's not a crime, it's not guilty conduct to have $5,001 in a safe deposit box. That's not that's innocent conduct. Well, if you want to criminalize that, you just treat it as if it is guilty conduct by how you treat it. Instead of going through the whole process of creating a law, which would be an invalid law anyway, but let's say you went through the whole process and created a law. It went through, we're talking federal, right? Federal or state, doesn't matter. You create a law through the legislature in the appropriate way. And let's say you criminalize possession of $5,001 on you, anything over 5,000. Well, that would never fly. First of all, you would never be able to pass a law like this. So, what they want to do is they want to just treat that conduct as if it's criminal. So, you got to pay attention to this, guys. You have to pay attention to this. It's the same issue as gun control, except for gun control is typically passed by the legislature. It's still invalid, but all right. Let's continue. Where did I? D, notice attached an asset list of items seized from the USPV safe deposit boxes and listed the deadline to contest forfeiture slightly over a month from the date the notice was issued on June 24th, 2021. They give you a month to contest the forfeiture. On June 9th, 2021, plaintiffs filed their first amended complaint against the government, alleging inter alia claims for return of property pursuant to federal rule of criminal procedure and violation of plaintiffs' rights under the Fourth and Fifth Amendments. A few plaintiffs also filed an application for a temporary restraining order asking the district court to enjoin the government from continuing with the forfeiture proceedings. The district court granted the application because the forfeiture notice, put bluntly, provided no factual basis for the seizure of the plaintiff's property as needed to comply with due process requirements. During the litigation, nearly all plaintiffs and class members ultimately had their physical property returned. The government then moved to dismiss plaintiffs' complaints, arguing that their action had become moot. Plaintiffs argued that their action was not moot because the government still retained records of its search, including the agent's notes and photos of box contents and video, we heard. And they sought an injunction ordering the government to sequester and return or otherwise destroy the records generated during the inventory of USPV deposit boxes. The district court dismissed most of plaintiffs' counts involving physical return of seized property as moot, but however, the district court held that the plaintiff's claim for return of property pursuant to Federal Rule Criminal Procedure 41G was not moot, citing our case law interpreting that rule, which allows, under certain circumstances, an order requiring the government to return or destroy all copies of records that it has seized. To understand this remedy, we must briefly discuss Rule 41G and our primary case interpreting it. And that would be CDT at 621, the third federal reporter at 1172, if you care. Okay, 1259. Federal Rule of Criminal Procedure 41G provides, quote, a person aggrieved by an unlawful search and seizure of property or by deprivation of property may move for the property's return. In CDT, which is looks like it's an appellate decision that was fairly recent, probably like 2010. We explained that though styled as a motion under Federal Rule of Criminal Procedure, when Rule 41G motion is made by a party against whom no criminal charges have been brought, such a motion is in fact a petition that the government and court, the district court, invoke its civil equitable jurisdiction. So what it's saying is there is a rule that allows um, a victim of government illegal search to and seizure to get the property back by suing the government. Okay. Citing the advisory notes to the rule, this case panel, CDT, explained that in some circumstances, equitable considerations might justify an order requiring the government to return or destroy all copies of records that it has seized. The CDT court did not list the circumstances in which such an order is warranted, but instead provided that what circumstances merit this remedy is left to the discretion of the district court in the first instance. It went on to affirm the district court on two bases. Equitable considerations require sequestration and the return of copies of evidence because the risk of harm to the plaintiffs associated with disclosure of the evidence was great. And two, when the government comes into possession of evidence by circumventing or willfully disregarding limitations on a search warrant, it must not be allowed to benefit from its own wrongdoing by retaining the wrongfully obtained evidence or any fruits thereof. Now, let me show you how to get to CDT. Um, I'll go to Google Scholar. Okay. And we'll just go ahead and go to Google Scholar. What you want to go to Google Scholar, go to case law, go to federal courts, and then let's try CDT. See what comes up. CDT 621. There we go. This is it right here. Yeah. 621, the third series of the Federal Reporter, 1162, which this is quoting 1172. So let's click on this. So this is you see how fast I was able to get this? Let's scroll down to 1172. Who was on this? Kaczynski was on it. Judge B. Oh, all right. So this is a Ninth Circuit. Yeah. Okay. Scrolling down till I see 1172 in the left column. You see that? 1170, 1171, 1172. See that right there? So this is something you want to have in mind, maybe pulled up or printed out while you're going through this. If you wanted to do a deeper dive. For you students out there, if you're writing a paper about this, I'm just walking you through the steps of how you would go through and write a good paper with good source material. Don't have AI do it for you. You can't trust AI. You got to do it. Not to mention, you have to develop the skills yourself, right? So I'm showing you how to do it. All right. In reaching its conclusion, the CDT panel, what does he mean by panel? I just I'll just show you really quick. What he means by panel is the three-judge panel. And that would be this right here, per curiam decision with these three judges. Oh, wait, hold on. It was en banc. Oh, hold up, hold up, hold up, hold up, hold up. Before Kaczynski, Kleinfeld, Graber. This is en banc. So normally it's before three judges, but this is in front of an en banc. That is usually it's like 10 judges from the Ninth Circuit. And this is 2010. Oh, I was correct. That's what they mean by panel. All right. In reaching its conclusion, the CDT panel referenced the fourth factor of the Ramsden balancing test. You're thinking, what's that? Well, that's another footnote you could, I'm not going to go look at it, but you could if you wanted. Typically applied to Rule 41G motions in criminal proceeding, whether the government showed a callous disregard for Fourth Amendment rights of third parties. Okay, keep that language in mind. Callous disregard for Fourth Amendment rights of third parties, that is, innocent parties, and explained that when the district court determines that the government has obtained the evidence through intentional wrongdoing rather than through a technical or good faith mistake, it should order return of the property without the need for balancing that is applicable in a more ordinary case. In a separate concurrence, 5 judges explained that the government had also violated its duty of candor in presenting a warrant application because it created a false impression that if the magistrate judge did not issue the warrant soon, the evidence would be destroyed. That's Kaczynski concurring. We just saw, you could look at that concurrence. I'm going to pull the case up again. It's referring to. This is the concurrence that's being referred to right there. All right. And you could search this by just searching concurring, and that'll bring you directly to where that opinion starts, which is on 1178. And you could read it yourself. There's no shortcuts here. This is how you have to do it in order to build not only confidence, but competence, confidence and competence. Confidence that's not based on competence is not adequate confidence. There's no shortcuts here, people. There rarely is with excellence. You got to go through it. That's why people don't keep the FBI accountable, because people don't do the work necessary to think through these issues. You can't just rely on lawyers to do this, people. First of all, lawyers are really busy. Secondly, um, you know, the way that law school trains people is to think like an advocate for one side, when you're getting paid, by one side. And that's not necessarily the the way voters should think of this. But if you were to think of it like that, you might want to think of it like the government always has a high duty to be above and beyond reproach. And when these people have to sue the government to get their stuff back because the government just says, no, it's ours, that your red flag should be going up with you. Okay. A separate concurrence. Okay. The concurrence stated that a lack of candor in this or any other aspect of the warrant application must bear heavily against the government in the calculus, any subsequent motion in the calculus of any subsequent motion to return or suppress the seized data. Okay, now we're on the district court's order. Having resolved the motion to dismiss, the district court certified a class of plaintiffs defined as all renters of U.S. private vault safe deposit boxes who had property within their safe deposit seized by the federal government on or around March 22nd, 2021. B, have identified themselves to the FBI since the seizure. And three, that's funny. And three, have had their property returned to them. After all briefing was filed, the district court notified the parties that matter was submitted on the papers for trial on the briefs on September 29th, 2022. This is over a year later. It's a year and a half later. The district court issued its order granting judgment in favor of the government. So they had their stuff seized a year and a half ago, and then the government says, yeah, they can keep it. They can keep these records. Plaintiffs had argued, among other things, that the government callously disregarded their Fourth Amendment rights because the government's search and seizure exceeded the limitations set out in the USPV warrant, and that the government breached its duty of candor by misleading Judge Kim in the warrant application. The district court rejected both arguments. First, by the way, I looked up that district court judge. I think he was a Republican, so boo, boo. The district court rejected both arguments. First, it reasoned that plaintiffs' claim that the government exceeded the bounds of the warrant hinges on whether the government's actions were valid inventory pursuant to inventory search exception to the warrant requirement. There are exceptions to the warrant requirement that have been laid down typically by judges in like a common law kind of a fashion. They get away with this a little bit more with Fourth Amendment because the language of the text of the Fourth Amendment controls, and the language does say you have a right to be free from unreasonable searches and seizures. Well, the language of unreasonable gives judges a lot of power to decide what's reasonable, what's unreasonable. And this power is attached to the language of the Constitution. It's unlike Second Amendment litigation, I would say in the last 25 years. It's unlike Second Amendment litigation in the sense that there is no language of reasonability in the Second Amendment. It's a flat command to the government. The right of the people to keep and bear arms shall not be infringed. It doesn't say that the right of the people to keep and bear arms shall be cabined by reasonability. It doesn't say that. The Fourth Amendment does have the language of reasonability within it, and the text of the Constitution does control along with the history and tradition, but you got to start with the text. So now I know that you feel like you could drive a Mack truck through this confusion in the language of reasonability here. What's reasonable to the FBI and to this district court judge is obviously not reasonable to the plaintiffs. That's not to say that reasonability is subjective and relative, that there's no truth of the matter. I'm not saying that at all, and I don't believe that. This court definitely doesn't believe that. You have to keep pressing the point, and this is what this Ninth Circuit panel is doing. Good for them. The plaintiffs argued, among other things, that the government callously disregarded their Fourth Amendment rights. It exceeded the warrant. The government breached its duty of candor by misleading the judge on the warrant application of their true intentions. The district court rejected both arguments. First, it reasoned that the plaintiff's claim that the government exceeded the bounds of the warrant hinged on whether the government's actions were valid inventory pursuant to the inventory search exception to the warrant requirement. Because plaintiffs failed to show under the rules governing that the exception that the government's proper investigative motive was the only reason the government opened the safe deposit boxes, the district court concluded that the government's inventory was not pretextual, that is, BS, was not BS. Thus, having found a valid inventory, the district court necessarily found that the government did not exceed the bounds of the warrant. Okay, hold on, because they're about to reject this reasoning. So they're just laying out what the reasoning was at the lower court. Second, the district court held that the government did not breach its duty of candor by misleading the magistrate judge in its application for a warrant. Plaintiffs argued that the government omitted from the supporting affidavit that it intended not only to inventory box contents at USPV, but to civilly forfeit them as well. The district court held that this kind of omission was immaterial. Wow. Wow. The district court held that this kind of omission was immaterial. How could that be immaterial? However, and that any reasonable magistrate judge would have inferred that the inventory could lead to potential discovery of criminal proceeds in certain boxes, which would then lead to forfeiture. The district court therefore denied plaintiffs' requested relief. Wow. Wow. That's painful for me to read. We're going to stop there today, but we're going to go to the standard of review and the analysis next. And this is where they take down the district court's reasoning on this. We don't have a lot left. Here's the conclusion right here. So, but what's about to happen, and the rest is footnotes. What's about to happen is a very good example of an appeals court doing its job and discovering errors and the a decision for the government and improper, unclear reasoning. Just to be clear, the government put any cash over $5,000 in a forfeiture, gave it a forfeiture number, and it always intended to do this. Any cash over $5,000. They ran it by drug sniffing dogs, all of it. They never said that they were going to do that in the warrant application. So there's ample evidence for this appeals court to find that the government really intended to seize everything, including innocent parties stuff. And the government not only should have lost, they should have lost big time. They should pay the attorney's fees, and they should be embarrassed publicly. Not to mention, here we are on Christmas Eve, 2024. U.S. senators are considering, even as they spend time with their families, hopefully, how they're going to vote in terms of who runs the government, as far as executive branch appointments and as far as judicial branch appointments. Look at how important it is to have the right judges in there. It's very important. This is in front of Carlos B., Mylan Smith, and Lawrence Van Dyke. Let's take a look at who B is. Just go B, Ninth Circuit. Okay. And we'll just take a quick look. Republican Party, appointed by George Bush. Who's writing this? Opinion by Milan Smith. I think he's a Democrat. Let's take a look. Brigham Young. Well, maybe I was wrong. Let me see here. As an American attorney, his brother was a Republican U.S. Senator. Milan Smith is neither a Republican nor a Democrat. He considers himself to be an independent. Wow. Who appointed him? George Bush. Well, he was appointed by George Bush. Okay. So that's who's writing this is a Bush appointee. And then Lawrence Van Dyke, you know that, right? You know who he was on the podcast last year. Van Dyke, he was appointed by President Trump. Oh, I should have said Ninth Circuit. It pulled up Dick Van Dyke. Yeah, we really enjoyed covering his opinion in McDougal versus Ventura County last year. It was a year ago that we did that on the podcast. So, yeah, Donald Trump appointed him. Praise God. So we got three Republicans, I think it's fair to say, on this panel. Thanks to George W. Bush and Donald Trump and the U.S. Senate that was Republican that appointed, uh, that rubber stamped this appointment. That's what we're getting here in California, upholding the Fourth Amendment. Now, the um, the original decision was, I think, also written by a Democrat, or sorry, a Republican. So you're going to get a mixed bag um, with some Republicans, but um, at least in this case, Republicans corrected the error of other Republicans. So we do the best we can. We keep moving forward. So Merry Christmas. Yeah, I just looked it up. It's Gary Klossner is the judge at the district court, and he was Republican, appointed by George Bush. So I was correct. I did look that up, but I looked it up a while ago, so I wasn't. I didn't know if I remembered it correctly. So this is the Fourth Amendment on the Republican Professor. It's Republicans correcting decisions and problems that were caused by Republicans, and we're going to keep moving forward on that theme. Merry Christmas. It's December 24th, 2024. I'm in Tennessee visiting family, and I'm maybe going to do one tomorrow on Christmas. I'm not sure. Depends on, well, frankly, it depends on whether I want to or not. But we'll see you next time to continue. Either way, take care.